All right, welcome back to KFYR Plus. And according now to a recent study, two-thirds of U.S. adults do not have a will. Now, this could leave serious implications for family members. And joining me now is Russel Morgan, estate planning expert. Welcome, Russell. Thanks for joining me today.
Thank you for having me, Jay. Good morning.
Good morning. Well, let's talk. What is the purpose of a will and why is it important?
The purpose of a will is to make sure that the right people end up with your inheritance, the right people end up with your assets, and equally important to make sure that the right people are in charge of your estate to be able to collect assets, to be able to pay off your creditors, and distribute the remainder to your next of kin or whoever you intend to leave your estate.
So, what happens if we do not have a will? As we mentioned, well, two-thirds of the U.S. adults do not have one. What happens then?
Unfortunately, the state laws would have to step in at that point, and each state laws are different. There are states that essentially dictate certain parties to be entitled and certain parties to not be entitled. And by not having a will in place, you're rolling the dice with who will be in charge and who will receive, which is ultimately what we want to avoid by ensuring that we have things like last will and testaments and living trusts in place.
Hmm. Can you explain the difference between a will and a trust?
Sure. So a will is a writing that has to be approved by the court after death. It's something that requires court approval in order to be effectuated, meaning in order for it to be legally binding after death. Your trust, however, is completely standalone. Your trust does not need to be approved by the court. Your trustees don't need to be appointed by the court the way that your executors do under your will. The key difference between the two, and really the most common error that we see, is many people don't realize that you have to fund the trust. It's the most important part. And many people don't realize that not funding your trust essentially ends up back in probate, which is the court proceeding that we're trying to avoid by creating your trust in the first place. So the one of the main reasons why we always recommend trust planning is avoiding the courts after death.
Okay, so when you say fund your trust, what does that mean?
Funding your trust means transferring assets to your trust. So as an example, when we put a piece of property, or let's say we put a house into your trust,
Hmm.
and we write in your trust that we want it to pass to a certain person, that in itself doesn't make that asset part of your trust. We actually have to transfer the title to your home from yourself to the trust itself. So funding your trust is transferring the title to your property to the trust itself.
Okay. And how does having a will or trust affect the distribution of assets after someone passes?
Having a will or trust dictates the right people that you want in charge and the right people that you want to inherit at the time of death. The difference between having a will and trust and not having one is the law essentially directs who receives from your estate and who's in charge of your estate if we don't have a will and trust in place, versus having a will and trust where you're in full control. You're deciding who receives, you're deciding who's in charge, and essentially controlling distributions over time after death.
Why do you think so many people don't have one, a will or nor a trust?
I think one of the main reasons and what we see most often is nobody plans to pass away.
Hmm.
And unfortunately, many of our clients have unexpected deaths. And that's one of the main reasons why we don't see it in place. The other reason, and most common, is people don't believe they need to have anything in place and hope for the best. And that's the worst decision that we see people make on a regular basis, is ultimately the law steps in, and many times the people that they had no intention having any part of their estate whatsoever not only end up being put in charge, but more importantly, end up inheriting their assets.
Okay. Can you explain the process of creating a will?
Of course. So, creating a will on a very fundamental level is a breakdown of all of your family tree. Who are our next of kin? Who are the people that we want to inherit our assets? What type of powers do we want to give them? Do we want them to sell everything off when I pass away and simply distribute the funds? Do we want to leave something specific like a coin collection or a piece of art to someone in particular? Do we want to simply distribute the entire estate by percentage, or a combination of all of the above? Equally important, and one of the more difficult issues that we face, is what happens if the people that we have in mind don't survive us? What happens to our property? Who's in charge? Who are our successors? Who are our successor executors? Who are our contingent beneficiaries if, God forbid, the parties that we do want to put in place don't survive? So it's something that we do in steps, first to lay out the foundation and ultimately end up with a finished product that preps for as many contingencies as possible today that we can plan for tomorrow.
Mr. Morgan, is this a costly setup to get a will going?
It's not a costly setup. It's something that is relatively inexpensive. It's definitely something that we recommend for all people to put in place, especially trust planning. One of the common misconceptions is trusts are for the 1%, which is something that we preach regularly, that trusts are valuable tools for all people.
Yeah,
Same
even
goes
if you've
for
got.
wills.
Yeah, I'm sorry, I jumped in there. I was just going to say, even if you have minimal, I guess, assets, you should probably get that assigned to someone that you would want to have that. Otherwise, like you said earlier, somebody that you don't think should have them will take your assets from you, I guess.
Absolutely.
Are handwritten wills valid? Does it go state by state?
So it depends on the state law. Different states have different laws that apply to handwritten wills. Handwritten wills are what are called holographic wills. Uh, State laws vary, and there could be a wide variations on whether or not holographic wills are even admissible. As an example, holographic wills in New York are not admissible with certain exceptions. In states like California, Nevada, and Texas, they are invalid. But in others like Indiana and Florida, they are valid. So this is another reason why we recommend, at a minimum, speaking to a lawyer, even if you're preparing your own will and it's something that you're doing on your own, at least consult to make sure that it's valid and binding in your state.
Are there any specific situations where having a trust is more beneficial than having a will?
It's That's a great question. Having a trust is definitely more beneficial, especially where we have things like real estate. Any type of ownership of property is one of those assets that we can't leave transfer on death. We can't designate a beneficiary on the deed to our house.
Mm-hmm.
So, and this is one of those assets that oftentimes gets tied up in the courts after death. And one of the types of assets where we do recommend placing it in trust to get it transferred as quickly as possible from the person's estate to whoever they intended to leave it to, or equally important, to get it sold as fast as possible if we're dealing with a mortgage or a line of credit or a judgment that would otherwise snowball having to go through probate if we left it by will.
When someone puts together a will, how often should they review it and update that will?
It's a matter of changing life circumstances. So it's something that should definitely be reviewed when we have major changes and major life events. Things like the birth of a child, the death of a family member, a move, a marriage, a divorce. So we usually recommend at least every couple of years, check in with your lawyers just so we can review and see if any of your current life circumstances warrant us making changes to your will and or trust.
We live in a digital world, Mr. Morgan. What do we do with our digital estate?
Digital assets are one of the newest things that we're including in all of our estate planning. Digital assets can be left specifically, meaning to someone that we want to choose in particular, or they can be sold. With now we have online assets that are actually worth money, things like Bitcoin, for example, that can be sold after death. So it is something that we provide for specifically in our wills, and we are one of the very first and few law firms that have created trusts for digital Bitcoin and digital currency.
What are some of the challenges that people face when it comes to estate planning?
Some of the challenges would be definitely inaccurate, incomplete, or contradictory information. People try to do these things on their own. They try to create wills and trusts by themselves. There
Mhm.
are a lot of do it yourself forms out there, which for the most part are extremely helpful. It becomes problematic when it's not reviewed. What sounds right to a layperson is not necessarily what the law says. So one of the major challenges are inaccurate, incomplete, or contradictory information. If you're creating a will using an online questionnaire, for example, there's a possibility that you may leave out important information that could prevent your will from accomplishing your goals. There's also the added problem of adding in additional information in one side that may contradict a different part of your will and trust.
Okay. There are three things in life that are constant, and you probably know what they are, Mr. Morgan: death, taxes, and change. So, with the death, you've got the will. With the taxes, are there any tax implications when it comes to a will associated with a will or a trust?
So there are definitely tax benefits in implementing a trust. This is one of the other reasons why trust planning is so important. There are benefits in passing your assets by trust to your spouse, to your children. There are certain exemptions that we can employ that otherwise are not, if not used, are lost if not specifically mentioned.
Okay. And should someone trust online wills as templates? You kind of mentioned it moments ago, but is that something somebody should trust in?
It's a good starting point, so it's a great jumping off point, but we always recommend at least have it reviewed by a lawyer at a minimum to make sure that it's valid, to make sure that it's accurate, and most importantly, to make sure that it's legally enforceable.
Okay. And can you explain the role of a power of attorney in estate planning?
A power of attorney is something that we use during life. If God forbid you become incapacitated, if God forbid someone has a stroke, Alzheimer's, dementia, some sort of condition that prevents them from making decisions for themselves, or something simple where, let's say, I have to conduct a transaction and I'm not present in the state. A power of attorney allows me to name someone else who has the ability to sign legal documents for me. So it's something that we use during life that only has an effect during life and is then replaced by your will and trust after death.
Gotcha. Mr. Morgan, I did an informal poll around with some friends on whether they had a will or a trust, and the answer was zero. Zero of my friends had one. Of course, we're all fairly young, but like you said, you just never know when death will come a knocking, and it's a good idea to get this going. I was surprised 2/3 of U.S. adults don't have a will. So, great information from you, Russel Morgan, the founder of Morgan Legal Group. Thank you for your time this afternoon. Appreciate the expertise.
Thank you, Jay, for having me. It was a pleasure.
Take care and have a great day now.
All right, you as well. Take care.
All right, time now is 1:45 here at the KFYR Plus News Desk. Let's take a break. We're back with a look at entertainment news coming up next.